Hey everybody, we are back again with another podcast. I know it's been a little longer than usual. If you're up to date, hopefully maybe you're not quite up to date yet. You still have a couple in the queue. If not, here we are again. Today we're going to be talking about joint ventures. I've got Dr. Lance Rosa with me and Mrs. Madison Hess. They're going to be kind of leading us through this discussion, as I will be quite honest to say this is not my forte. So I'm going to play the person that doesn't know anything about this. I'll be very accurate at that, and I'll be peppering these two with questions as much as I can. So guys, joint ventures, what are they? What are we doing here?
Yeah, Steve, this is one of those topics, you spend a lot of your time on the employment law side and helping and coaching people through that negotiation process, getting into employment law agreements. Madison and I, and particularly Madison, spends a lot of time on these joint venture agreements that are popping up all over veterinary medicine currently. I mean, in the last year, Madison, what do you think we've seen 20 of these?
Definitely 20.
So what we're dealing with here, Steve, are veterinary practices that are either taking an existing associate or more commonly hiring an associate and almost instantly elevating them into partnership status. And so when we say the words joint venture, another way to really kind of say this is a partner. And every time what we see is we see the corporate veterinary practice, so a group owned veterinary practice, corporate large group is the majority partner, and then we have a veterinarian or maybe two veterinarians that are minority partners. And so the splits that we usually see on the equity percentage are, 70-30, 80-20, 85-15, something along those lines, where that veterinarian owns a little bit of the veterinary practice, 15, 20, 25, 30%, something along those lines. So now we have a true partnership, right? So we have a situation where we have a majority partner that is managing and making decisions and controlling the business of veterinary medicine. And then we have a veterinarian that is a minority partner. And from the get-go, Steve, I'll tell you that is the kind of the foundational premise of this. And so in a business, when you have greater than 51% or greater than 50%, you're the majority partner and you are in control. So by default here, our veterinarians start out behind the eight ball. They start out as a minority partner, aka not in control. And so Madison and I spend an inordinate amount of time working with veterinarians that have been approached from practices in joining or starting these joint ventures, or veterinarians that are already in these joint ventures that are dealing with partners or dealing with problems arising from this joint venture. I don't know, Madison. We probably see seven or eight different kind of players in the veterinary space right now, corporate groups that are starting or that are using these models to either buy existing practices or more commonly start practices from scratch. So they're using this as what they call their de novo startup package. A few practices, a few of these groups are buying existing practices and putting veterinarians into this joint venture model. What else do you want to know, Steve? What other does that do a job justice in describing it to you?
It does, and like what I'm thinking about as you're talking about it, I'm like, okay, so this is very different from like the older veterinarian who owns the practice offering a partnership share to the younger veterinarian that's maybe been there a few years, proved that they can pull their weight, thinks they want to co-own, or are they the same or similar? How does
Fundamentally, this is not really different than that. So if you have a veterinarian or maybe two or three veterinarians that own a practice and they want to bring on their fourth practice, or say, veterinarian that has an associate that's a high performing, high producing associate and wants to bring them into a 15 or 20 or 30% ownership stake. Fundamentally, legally, there's really not a whole lot of difference here. But in the real world, there's a ton of difference here. And here's why is when we're dealing with that veterinarian to veterinarian transaction, we have two veterinarians, three veterinarians, four veterinarians that are partners. Typically that's a pretty friendly arrangement, overall. We may have a hometown lawyer or, somebody like our law practice that writes up the partnership documents and partnership agreements. And when we write these for veterinarian to veterinarian transactions or veterinarian partnerships, we obviously write them as friendly and cordially as possible, as succinctly as possible, as clear and transparent as possible. And that really is the difference between the veterinarian to veterinarian world and the corporate as the majority owner and veterinarian as the minority owner. Think about who's on the other side writing these corporate documents. A private equity group, a private equity group's lawyer, a lawyer that is their goal and their job is to put that corporate group in the best possible position. And they already hold all the cards because they're in the majority position already. But through and through the documents, and Steve, these are incredibly complex documents. They're hundreds of pages of long. There's multiple documents. The documents refer back and forth to each other. There are very complex legal strategies and very complex legal provisions in there that aren't in your day-to-day documents. This is not like a 5 or 10 page employment agreement. These are hundreds and hundreds of pages. I can't really overstress the complexity, in these documents. And therein lies the issue is when you have hundreds of pages of dense text, dense legal text, you can really put some onerous and restrictive provisions in. And that's what's happening here, Steve, is that private equity group is using this opportunity to put that veterinarian in a position that is very restricted and it's very onerous, overall.
Yeah, so what I'm hearing is it's a lot more, not more a lot more complex when it's not a veterinarian to veterinarian relationship. Maybe you guys can kind of give some examples of where those biggest layers of complexity lie that might trip someone up that's not used to reading, this type of dense agreement and understanding what it means.
Yeah, Madison, I mean, off the top of your head, what do you think what are your thoughts as far as what are the most restrictive and problematic provisions that we run across in these documents?
I would say the most restrictive provisions come in when you're talking about how you get to get out of this kind of a partnership. And also, I mean, if there is an exit for you, which a lot of the time there is not, usually there's not, unless we push for it really hard. It's very rarely there when we get the documents. Is what will it look like when you get out? Because one thing that we see is that they can have stronger restrictive covenants when you're in a partnership position as opposed to if you're just an employee. So if you work for them, the kinds of non-compete provisions that you might have, how big that radius is, and how long it lasts would be more condensed. They'd be smaller than what it would be as if you're in a partnership position because the law treats that differently because you have an ownership interest.
Even if
Let's
I'm in
kind
a
of
state with no non-compete, like Wyoming or something like that.
Yeah, you can take a Wyoming, you can take a California, Oklahoma, Maryland. All don't enforce non-competes against veterinarians. And here's the key language, Steve, in employment agreements. But we have departed the world of employment agreements. We are now in the world of ownership and partnership agreements. And therein lies like one of the fundamental reasons why practices, group practices, corporate practices want to do this is because this does give them access to more enforceability on more restrictive agreements. I mean, case in point, the one that Madison and I saw, what was it yesterday, Madison? Kind of the reason why this podcast was prompted is the restrictive covenant in that agreement was 50 miles from any and all practices locations that the corporate owned. And so we don't even know where all those locations are. And we don't
Right.
know where they're going to be in the future either. And then you start to get 2 or 3 locations spread out in a state, then we've got the entire state that's restricted. And so, a very onerous provision that we don't even know the extent of.
And I
And
feel like a lot of where that comes from is like when Steve asks, how is, this different from when a private veterinarian is bringing somebody on as a partner? Because structurally, like you said, Lance, it's the same thing. Like the documents are in theory, like, the same titles, like we're talking about the same stuff, the same kinds of agreements are being made. It's just where it all comes from. Because when a private veterinarian is going to bring on a partner, the motivations of that private veterinarian are not the same as the motivations of these companies when they're thinking about bringing on a veterinarian as a partner. And so you have to look at the documents from a different frame of mind, because the private veterinarian is thinking so many things. They're thinking about what's good for their practice and what's good for their clients. Probably what's good for them in the long term is they're thinking about retirement, what their options are there. And if is this person going to do a good job filling my spot? Corporation is thinking about how we make money. How do we build something that makes money, that's worth something, so that we can sell it and make more money?
yeah, yeah, precisely. And therein lies like kind of a fundamental thing that we need to talk about is why are practices doing this? Why don't they just hire associates? Why are they selling, part of their practice to, these veterinarians? And I'll be perfectly honest with you, it's not because they're altruistic. It's not because they want these veterinarians to get money. It's because it allows them the potential to lock those veterinarians in place. Most of us live in at-will states, at-will employment, and we can come and go, as we please. And in a partnership agreement like this, that's not necessarily the case. You're locked in. And when I say locked in, I don't want you to think, we don't have slavery or indentured servitude in this country, but the practice can certainly lock in your money, and they can make it very painful for you to leave. They can't force you to work there. That would be slavery, but they can keep your money. And we're talking 3, 4, 5, $600,000, and kind of the lighter cases, a million, million two, million three in the heavier
And
cases.
like you were
Um,
saying, Lance, they can also make it difficult for you if you want to leave. Well, where are you going to work? Because
yeah.
when you were in this partnership position, the company had a greater ability to restrict where you might be able to go on the back end. So sure, you can leave, but we're keeping the funds. And also, where are you going? Where are you going to go to
Yeah.
work?
Yeah, and this kind of brings up another point, Madison, which we haven't really talked about yet, is how does all this happen in real life? And so how this happens in real life is the practice says, hey, we want to bring you on as an associate, or we want to bring you on as a partner, we want to bring you on as an owner, we want to bring you on as a joint venture, whatever language they use, and we're going to loan you the money. And so we're going to extend to you a promissory note, or you're going to extend to us a promissory note, and you're going to promise to pay us 3, 4, 5, $600,000, a million, million three, overall. You're going to pay us this money, and you're going to pay for your shares over time. Well, now, Madison, all of a sudden, it's like, okay, we can't leave. We don't have any way to buy our shares out of the company, but we still owe $600,000, and we can't get a job somewhere else. So, you're really kind of locked in, by virtue of you still owe this money on this promissory note, no way to pay it back, and no way to get the asset, the underlying shares out of the company. And so when we talk about, hey, there is really no way out, that's the functionality of there's really no way out. Not because you can't just walk out the door and leave,
Right.
but you owe $600,000, and you have money, invested in the company as well. So it's not like veterinarians are laying down hundreds and hundreds of thousands of dollars. We do see some veterinarians that are putting up 25, 30, $90,000, as part of payment for their shares, which is almost even scarier to me, because now they have real money that's invested, in this situation as well, not just this promissory note, that gets paid out. Um,
Sure.
and so I kind of want to take a step back for a second. We talked about why the group practices want to do this. Why would a veterinarian want to do this? Like
My
that's
question. Hello. Yeah.
Oh, I
Hey.
have a theory. I have a
I'm,
theory.
I'm like, is it I want some level of control? Is it I want the windfall at the end? Is it just YOLO? Like, what is happening?
Yeah, well, okay. So all of those things could be true. Madison, what are your thoughts?
I'm always trying to imagine how the initial conversation goes when veterinarians are approached by corporate and corporate try to paint this picture for them. And I don't know because I've never been in the room for that, but I have a theory that essentially what they're telling them is you're going to be here working anyway. You might as well be in a partnership position so that you can get distributions. I'm guessing that that's how the conversation goes. But what were you going to
Yeah.
say, Lance?
I mean, I think that's a part of the conversation. I'm speculating too. I haven't been in one of these conversations either, but I'm sure it has a lot to do with, you're going to be an owner, you're going to be the leader of the practice. Let's get you into a partner. They use, I think, a lot of language, along those lines, which is true, right? Those are all true, but it's definitely not all, it's a lot, there's a lot of marketing involved with that as well. Here's how I kind of think about things in my brain. So I kind of think about a spectrum, or a line graph of where veterinarians can kind of land in their career. On one hand, we have the associate land, right? We're going to be an associate. We're going to be an associate for, for the rest of our career. And there's a certain level that veterinarians kind of top out, in associate land. I mean, there's just only so much that you can produce, only so much the practice can pay, et cetera, et cetera. On the complete other end of the spectrum, we have a full practice owner, 100% of the ownership of the practice, 100%, all the debts, the liabilities, the responsibilities, the roles, the whole thing. Like they own 100% of the practice. All right. So these joint ventures kind of sit in the middle in my book. And so you're right, Madison, where we have like, okay, you're going to be there working already. You might as well go ahead and partake in some of the distributions and, and some of the profits that are coming, from the fruits of your labor. But you're not taking on all of the roles and responsibilities and the liabilities that come with being a full practice owner. From my perspective, if a veterinarian is entrepreneurial, if they have that desire to own their own practice, then they should go own their own practice. These partnership agreements, these joint venture agreements are not a suitable substitute for that. It's you're not a true owner, you're a minority partner in the practice. If you have that entrepreneurial itch, if you think that you can do it, which most veterinarians can, by the way, go be that full owner. And for where I see these kind of come in, and we counsel clients exactly on this conversation as well. And so where I see these really come in is I'm already going to be working at this practice, and I don't have any plans to go or move or anywhere else. I don't have plans to go start my own practice, own my own practice, whatever that situation looks like. I don't have plans to move, and I'm not going to do anything else. Okay, this is a reasonable intermediate step, and it's really for those folks that don't have the ability, don't have the desire, all of that stuff to be a full practice owner, but it's not a replacement overall. So it's a step up from associate. I get it. If the restrictions are okay, if the restrictions can be complied with. But the I also see everything kind of as a risk benefit analysis. And so, we have a little bit of benefit. We've got a little bit of extra distribution money coming in. Steve kind of mentioned it when you said, is there some sort of windfall that's coming at the end? Yeah, the reason that most veterinarians get into this, and part of that sales pitch that you were talking about, Madison, is okay, eventually this practice is going to recapitalize, and these shares are going to be worth a certain amount of money. And hopefully and ideally that the value of these shares that you've bought into are worth double, triple, quadruple, what you paid for them. And that's a windfall of money that you wouldn't have gotten as an associate veterinarian. It's just kind of like, hey, I got this money. I was doing all the same stuff anyway. I wasn't overly, burdened and restricted, by the restrictive covenants and all this other stuff. I was going to be here anyway. Hey, it's some money that I can put in the bank. It's not retirement level money. I mean, it's going to be a couple $100,000, $300,000. It's a good starter for a retirement account, but it's not like, I'm walking away from veterinary medicine at age, 35 type money. It's not that kind of money, but it does provide a little bit of cash, there. That's really the fundamental underlying reason of why veterinarians would do this. But it goes back to that risk benefit analysis. If the risk of being restricted and not being able to move on to another job, the risk associated with the note, all this other stuff is greater than this benefit, which is like we talked about, at best is going to be, in the hundreds of thousands of dollars range, then don't do it. Like it economically, it's may not be worthwhile to take on that extra risk.
So we mentioned cashing out for the big windfall in the end, but I also heard you say you're locked in. How long am I locked in for? Is there a time frame before I cash out my windfall? Am I stuck there till a certain time, or what? Let's define how does locked in work?
Go ahead, Madison.
So locked in. Well, it depends on if you negotiate your documents at all. If you don't negotiate them at all, then you are locked in. Your funds are locked in, at least like Lance said, no indentured servitude in this country. You can walk out the door, but you're gonna have a lot of financial ties to this place until your shares are bought back, which might not ever happen. So in a sense, if the documents don't give you a clear path out, you are locked in until that potential sale happens, and we don't know when or if that will occur. But what we like to do is to work in a 5 year option for our veterinarians to, if they really want to do this, if everything else is adding up and the risks seem like they're worth the reward that could come out in the end, then let's at least give you a 5 year exit option so that if it's not going well, you do have a way out. But a lot of the time, if we don't push for that, it's not there. So you're in it for
Yeah.
the long haul.
At the very best scenario, Steve, this is a 5 year agreement. And that's like if all the negotiation goes well and we're successful and all that, 5 year promise, 5 years of your life. If things don't go well or if these don't get negotiated, then these are literally perpetual documents. They don't have a way out. The only way out is to wait for that practice to recapitalize, to sell, to flip, whatever word you want to put there. And that's the thing that may happen, but it's also a thing that may not happen as well. It's very speculative in nature. And so, you know, historically, practices have been able to recapitalize and flip, but historical, action doesn't necessarily predict the future. And so there's a ton of risk with not being able to get out at all. But 5 years is a long time, and that's a best case scenario.
Gosh, that's so true. I don't even think about that a lot, but I mean, we push so hard for that 5 years in negotiations, but that is a terrible 5 years if it's not going well.
Yeah,
That's a good point.
Yeah.
still
Yeah.
a decent amount of time. Yeah. Oof.
But we would never get less than that. I
Right.
mean,
Right.
Yeah.
So if I, you mentioned that there's going to be the non-compete, and that could force me to move. I could say, hey, look, I want to get out and on the promissory note. I could hopefully have a 5 year provision that lets me get out if I want to. Otherwise, I am there if I want to, get out with something, I'm there until the practice sells.
Yeah, usually, Steve, the docs have something in them that say that the board of directors may buy the shares back if they want to.
Their option.
It's their
their
option.
option.
Yeah, and so if they're feeling good that day, they'll buy them back. And I've seen that happen where
Yeah.
the thing goes to the board of directors and the board of directors like, we don't really feel like buying these shares back. That's it. That's the only way that you can
Right.
sell your shares, and move on. And so we want much more mandatory language in that kind of in that buyout, type situation.
Mhm.
Um, Other things that are super restrictive in these documents, Steve, is we see everything from attorneys in fact, where you are giving the corporate the permission to sign documents on your behalf. I want you to stop and think about that for a second. I'm granting the ability of this corporate to sign documents on my behalf. And we've got this future sale that we hope is going to happen, right? That's the best case scenario is we the practice recapitalize and we get our money, back out of the shares. But the corporate can sign documents on our behalf, which means more restrictive covenants, which means employment agreements, which means all sorts of other things that are usually not beneficial to you, right? And so just this broad grant. I mean, I don't even know if I would give my own sister the ability to sign documents on my behalf.
That's what I was going to say. Is I used to work in estate planning, and so we dealt with power of attorneys, and I've watched people struggle to decide if they should, make them effective now or if it should be, a springing power of attorney in certain situations. Like, people being so concerned about how to limit this. And that's when they're giving that power and authority to people that they are close to family members, to spouses. And this is not that. And it's just buried in there and you don't even realize it. And it's crazy.
It's literally hidden in a wall of text that's, 30 or 40 pages long. And, it's right there plain as day, once you find it. So, that is obviously very offensive to me, Steve. That's an example of like, that's clear overreach. The pendulum is swung so far in the unfair direction. It's not even funny. Other things that we see that are incredibly problematic and some things that we really aren't successful at negotiating out. Let's talk economically for a second. So, when we have this partnership, this minority stake, let's say that it's 25-75. In theory, what should be happening is 25% of the profits should be going to the minority share holding veterinarian, 75% are going to the actual company. But all of these documents have a management services fee hidden in them. And that management fee ranges anywhere from 4% to 7%. And here's the key language, Steve, of total revenue. And so let's just say hypothetically that the practice is 15% profitable, which is pretty standard for most veterinary practices that are out there. Well, if we're shipping off 7% of our revenue right off the top, that's like a 7% tax off the top. So now in reality, there's only 8% profits left at the end of the year, end of the month, end of the quarter, whatever else. And now we've got to divvy up that 8%, 75, 25. And so in reality, the distributions we're only receiving like 2 or 3%, not 25%. See the difference there? And so that management fee is an insanely onerous tax that you're paying your partner. So you're sending
That's where I was going. I was like, so I'm the minority partner paying my majority partner to manage what now? Like, I mean,
Yeah, so that's literally what we call the back office. And so it's payroll, it's
yeah,
benefits, it's
HR.
HR, it's
No matter,
paying
no
the
matter, no
bills.
matter, and I can't fire them if I don't like the good job, the HR job they do, or I don't like
Yeah, if they're
how.
not doing a good job recruiting, if they're not doing a good job administering benefits, if they drop the ball on stuff for employees, it's hey, that's it. And by the way, this is incredibly higher than what most veterinary practices pay for their management fees.
They're charging me a premium on top of that.
Yes, exactly. Exactly. And so we want to suss out some of those details like, okay, let's say that we have to pay a new associate a $20,000 signing bonus. Is that coming from the management fee? Is it coming from the profits of the practice, or are we going to double dip here and have to pay for this twice? So those are some kind of like structural details that we really want to know the answer to, because obviously everybody that buys into one of these practices, they want to hire an associate as soon as they can, so they don't have to work every single day, every single shift,
Sure.
100% of the time.
Yeah, I'm saying, so one of you, please give me a pro. What's my
Oh, I
pro?
was not going to give you a pro. I'm so sorry. I was over here thinking about capital calls and dilution of your
Oh,
interests.
yeah, yeah.
It's not a pro.
So Steve, up until now, we've been talking about what happens if everything goes well. Like this is the good
What?
news, right?
Wait a
So
minute.
so like, hey, we actually have distributions to
Right.
distribute, and we have money to pay the management fee. And oh, there's this chance that we could get bought out in 5 years, 7 years, 10 years, whatever else. That's when everything's going well, Steve. We haven't even got to the part. What happens if things don't go well? What happens if the practice doesn't make money? What happens if the practice is losing money? All right, now we get into the real fun stuff of what happens if we have to put more money into the practice. And this is where Madison and I have run into several clients that have several issues on. We thought everything was going to go well, but this practice did not start out well. And we've got to put in an extra 200, 300, 400, $500,000 just to keep making payroll. And what ends up happening, and Madison mentioned it, these are capital calls. And so the manager of the practice or the majority owner will say something like, "Hey, we got to put more money in, and either you veterinarian put in several $100,000, or we're going to put it in and we're going to dilute your shares out." So not only do you still owe all the money, but you now have less of the percentage, the less of the shares. And so a that's where things really start to run off the tracks, right? Even if you do want to reach into your pocket and put more money into the practice, then you have to ask the logical question: why are we not successful? What is going on here? Do I put more money after bad money, right?
Right.
And so that's a problem as well. And then we haven't even got to the fun part, Steve, of of
What part?
what's called a debt restoration obligation. And so what happens if the practice truly does fail? What if there's still debt that's outstanding on the practice? Do we have to reach in our pockets and actually pay that debt back? And the answer to that is yes, that has to happen. And so now we are personally responsible for the debts of the practice. And keep in mind that we're not in control. Like we don't get to control like what's bought, what lease is signed, who we're hiring. All of these things that lead up to we're either losing or making money, but we're responsible for those actions when we're out of control. See how that is a real problem in the end.
Yeah, yeah, because I mean, I always figure like somebody wants to become a part owner of something to be able to exercise some level of control.
Yeah. And everybody that gets into these, obviously they're thinking this is going to be successful, right? This is the only reason why
Or
they're doing it. We oftentimes have to be kind of that bad news bears that like these, not everything is successful in life. And sometimes things don't go well. And so, the money gets very real very fast. This is where we start talking about that benefit risk ratio, Steve. Like, are the risks truly greater than the benefits? Because not only do you have to do a good job, you have to trust your partner, this majority partner, to do a good job in managing the practice as well. And some of these folks are good at it and some are not good at it. That's the problem.
and this is a much, I think about my work, coaching people in their negotiation strategies, and we do a lot of, risk benefit analysis on a much, much smaller level.
Yeah. Yeah. So I mean, let's kind of start breaking this down a little bit and summarizing it to what real life veterinarians can use if they're approached on one of these things. And so, number one, if you're approached on one of these things, I have no problem to you listening to it all the way out, but walk into those phone calls with a massive grain of salt. Like they're going to paint a picture to you that's the best possible picture. Think of it as a true marketing, type conversation, a true marketing type ploy. And they're only going to paint to you what happens if everything goes absolutely perfectly right. And even then, know that there's a ton of documents that are coming that are very restrictive on the backside. Do not, and I repeat, I can't underscore this enough, do not sign a letter of intent. A letter of intent, a term sheet, a memorandum of understanding. Do not sign any of these until everything is fully negotiated out. It is very, very common that we come into these transactions and these deals after a term sheet or letter of intent is signed, and our hands are absolutely tied behind our backs as far as the negotiation goes. All of the points on that letter of intent are negotiable. The price, the interest rate on the note, and all of the stuff that we know is coming, the non-competes, these attorney in facts, the exit clauses, the put options that Madison mentioned, all of these things are negotiable, but they're negotiable on the front side, not when you're knee deep in the documents, on the back side. My third plea to veterinarians out there, if you're considering owning a practice, think about full practice ownership. Why do we need to do all of the work and send 75% of our profits to somebody else that's not even there? You're going to be doing all the leadership. You're going to be doing all of the management. You're going to be doing the day-to-day operations of the practice. You might as well make 100% of the profits at the end of the day. And so if you're thinking about a joint venture, go ahead and take that next step and think about full practice ownership. It's not near as hard as what you think it is. And the back office stuff that we talked about, payroll, benefits, accounts receivable, accounts payable, bookkeeping. I'll be honest, guys, that stuff's pretty easy. That's the easy part of owning a business. The people and the leadership and the planning and the strategy, that's the stuff that's harder. And you're going to be doing that anyway. You're going to be doing those things anyway. You can pay somebody to do your bookkeeping for you and not have to send 75% of your profits somewhere else. What else can you add to that, Madison? What are other pleas?
My plea is just that if you are approached with an offer like this, to take pause and understand where it's coming from. Because if the corporates are trying to sell you on it in a way that makes it sound like this is just a good thing for you, it's just common sense, it's just to benefit you in the long run. Just think about the fact that if they're trying to put you in a partnership position, it has more to do with motivating you to make money for the corporation at large and thereby, in theory, for yourself, and also with limiting the options that you have if you want to leave, if you want to do other things. They're trying to motivate you to make money and they're trying to lock you in. That's really what they're trying to do at the end of the day.
Yeah, yeah. And if you're okay with being locked in,
Right.
that's good. But we don't want it to come as a surprise as you're signing away 5 to 10 years of your life by signing these documents.
So as soon as it starts sounding like a timeshare pitch, I should get my hackles up.
Yeah. Yeah. I have Steve, I'll be honest with you. Uh I've walked into situations. It's like, oh, I'm getting pitched a timeshare. I didn't realize that this was happening. Like, you know, 10 minutes into the conversation, it's like, oh, I see where this is going. This is not what I thought I was walking into. So, if it seems like if you don't know what I'm talking about, then you probably haven't been in a timeshare pitch, but these are phenomenally high pressure sales. The pinnacle of high pressure sales. It's almost humorous to me at the end of the day.
Half the goal is getting you in the room, right?
Yeah. Yeah. Well,
Any
Steve, does that
final?
help out some? Do you understand
Well,
joint
I
ventures
mean,
a little bit
yeah,
more?
yeah, I do, and I can't believe I thought we were talking about the cons at first. Well, I mean, but at least, like the biggest thing that I know we want to do is, regardless of what anybody's final decisions are or anything, we're here to help and help you at least make the most educated decision possible. And
Yeah.
that's the end goal. Like if you want to wade into something, just know what you're getting into.
Yeah, I guess that does bring up a really good point, Steve. And so, as much as we laugh and talk about these and talk about how bad they are, if one of our clients truly wants to sign them, we go through the risk benefit analysis with them and we negotiate the documents to the fullest degree. We're not going to tell somebody that they can't do it. We want to put them on the best possible terms that we can. And our take on these is, and it's the same thing that comes from practicing veterinary medicine as well, is my job is to lay out all the options for you and to tell you this is the risk and these are the benefits and this is what the documents say and I'm interpreting those documents for you. This is what's hidden in them. We've read them top to bottom, right? And lay that out for our client, our veterinarian client, and then ultimately it's their decision to make. If they're fully informed on what the risk and the benefits are, then they can certainly make that decision. It's their life, it's their money. That I'm completely cool with that. So I'm not, if somebody walks into our office and says, I want to do this, we are not the people that say you absolutely can't do this on under no circumstances. It's let's have a conversation about it. Let's lay out the spectrum. Let's lay out all the things that could stop in the middle. Let's lay out all the risk. Let's lay out all the benefits and then let you make a decision. And then ultimately, mark the documents and negotiate the documents, all the way through to put you in the best possible position, moving forward. And so I think that's a different take than some other lawyers. Some other lawyers say, absolutely, these are horrible ideas. Don't do it. Not going to help you. We'll help you. We just want you to be fully aware of the risk going into it. And the 20 that Madison and I, talked about earlier, the majority of them ultimately ended up signing the documents. And so, it's some of them walked away. Some of them said, hey, thank you for telling me what the risks are. And thank you for laying out the facts as they are. And others said, hey, this is the best decision that's to be made in my life right now. Okay, absolutely.
And that's kind of the biggest thing. Like we want to be able to guide you to make the best, most educated decision possible.
Yeah.
Any final thoughts, guys?
Yeah. So, I mean, it kind of comes to summary for me is like, don't be naive in these situations. Like, I truly think that at a certain level, there is them counting on the veterinarian to be somewhat naive. And anytime that somebody asks you to sign hundreds of pages, dozens of pages of legal documents, that's really a good time to pump the brakes and really understand what's in those documents. So don't be naive going into the situation. Go ahead, Madison.
No, I was just gonna jump off of that and say if you're being told that it's not that complicated and you should just sign and not worry about it, that is your biggest red flag that you should absolutely take pause and read everything or pay someone else to read everything, whatever fits your
Yeah.
situation better.
Thanks to both of you. I really appreciate it. I mean, I learned a ton because I didn't, this is again, not my expertise. So I hope everybody out there listening or watching learned a ton. This is it for office hours this time. We'll see y'all next time.
Thanks, Steve. Thanks, Madison. See everybody.